Welcome. My name is Xenofon Dimitris. I'm a professor of biomedical informatics and data science here at Yale. This is an interview that we record as a supplement to a new program in medical software and medical AI. Guest today is Anat Lior, an assistant professor at Drexel University's Thomas R. Klein School of Law, and an A. Schmidt affiliate scholar at the Jackson School at Yale, and an affiliate fellow at the Yale Information Society project. I got to know Anat while she was at Yale at the Jackson School. Her interests include AI governance and liability, quantum computing policy, which we're not touching here, and the intersection of insurance and emerging technologies, which may have some impact actually, how AI, there's some interest in this area as to how you regulate software used by insurance companies. I've had some questions before, so this might be of interest. So let's get started on that. Thank you for joining us. There's a whole lot of regulations in AI, whatever AI means, in different countries. So if you give us a quick survey of what's out there before we get into the details here.
Sure, I will be happy to. So thank you for having me. I'm really excited to be here talking about AI regulation and policy, which is a topic I research and I really, really like. You touched about the problem with actually defining AI, and that's an issue that I keep on coming back to. Different regulation in different states and countries have different ways to define AI. I think the legal people who are writing those legislation are see this technology as very different from people who are actually developing it and people from the computer science department. I keep on telling my students that when I say AI as a policy lawyer, I usually just mean one thing, but I assume when I say AI to people who are actually working on it, that can be a million different things. And that's the first obstacle of creating beneficial and efficient AI regulation, the need to define it, which is extremely hard, but also kind of important in order to make sure that the regulation does whatever it needs to do and create some sort of safety and security to people who are using or developing it. So that's always the main first hurdle to pass. So in response to serving, I want to talk about a couple of countries. I'm going to start with the US, and we're going to talk more about the US, who has a couple of suggestions in the pipeline, or more generally ongoing. They are very much fragmented. There is no federal legislation. We have the AI Bill of Rights, which was published about a year ago, has a confusing name. We're not giving rights to AI. We're talking about people who are using AI, what they can demand, some sort of transparency and accountability. We also have the NIST AI Risk Management Framework, which is the National Institute of Standard and Technology, and a couple of acts: an Algorithm Accountability Act, the AI Training Act for the acquisition of workforce, which basically means that people who are working with this material or using AI, specifically in the government setting, need to have some sort of education regarding what AI does and how to best use it. We also have state level regulation. A lot of states, including Connecticut, I think also Pennsylvania, created committees, and the main goal of them is to assemble them and for them to create a report, give it back to the state, and the state to create some sort of legislation. This is still an ongoing process, but it's happening in a lot more states in the US. The court system and the common law perspective is always in the background. However, when I do torts, when torts means civil interactions that cause some sort of damages, car accident, malpractice. So most of the things that the accidents that lead to damages involving AI are usually settled outside of the court, and we have no idea what happened behind those closed doors. So the court system has not had the opportunity to actually give us what is the relevant rule, but we're still hoping that maybe they will have the opportunity to do so, and someone will be vigilant enough to not take the money and actually go to court, which is a very difficult thing to do because 90% of tort cases will be settled outside because it will take a lot of time. And the new AI executive order, which I think we'll talk about more, which was published on Halloween just 2 months ago. The EU has its own act, it's still a proposal, and it's a framework creating different AI practices according to 4 levels of risk. The first one is unacceptable risk, meaning we're going to ban it completely. High risk, limited, and minimal. The more dangerous it is in the classification pyramid, the more regulation the EU will impose. So certain AI practices that are considered a threat to safety, livelihood, and rights are deemed to involve an unacceptable level of risk. And as I mentioned, they are prohibited. But if we're talking about high level, such as biometrics, education, maybe police forces, the EU will create an obligation to register, to create risk assessment, human oversight, other obligation in that context, meaning that companies who are manufacturing it and using it will have to provide a lot of evidence, and we know that companies usually don't like the government getting into their business, and there's no reason to think otherwise, especially with AI. The proprietary information there, will not be happy to expose it. Limited risk AI would be subject to more transparency obligations, soft rule regulation, and it will be easier to go past that hurdle. The most important thing, or a very big part of the EU Act, is the fact that they have the European Artificial Intelligence Board. It will be able to impose fines, which is something that right now the US and other countries don't have. So they can impose a fine up to the greater of 30 million euros or 6% of total worldwide annual turnover. When it comes to companies like Google, Facebook, IBM, Microsoft, that's a lot of money. So the EU Act has teeth. We also saw this with the GDPR, the General Data Protection regulation that the EU is currently having, and they are imposing a lot of money and a lot of fines on these big companies. Canada has its own act. It's called Artificial Intelligence and Data Act. It's very similar to the AI Act in the EU. They are trying to hold responsible the people who have control over the technology, and they are trying to require the implementation of new governance mechanisms and policies that will consider and address the risk of their AI systems, meaning they are more proactive, more robust, somewhere in between the US, who is very flexible and hands-off, and the EU is much more proactive. China is an interesting example, mostly because there's allegedly an ongoing tech race between the US and China, trying to achieve some sort of AI win. I'm not sure how winning looks like in the AI tech race. I'm not sure if the singularity is the end goal, but there is a dynamics of competition that very much affects how countries approach regulation. So there are four main laws that are currently ongoing in China. I want to mention them because they're kind of new. We have the algorithm recommendation regulation from March 2022, trying to aim at companies, making sure that algorithms that are making recommendation are transparent, or at least have some sort of explanation process for users. We also have the deep synthesis regulation from January 2023, also trying to combat deepfake and AI, the way that AI is beneficial to deepfakes and the troubles that it creates. In July 2023, we had a generative AI regulation, probably in response to ChatGPT and other generative AI models that are currently very much being used. And lastly, in April of 2023, there's a draft of ethical review measure. I think it's one of the only countries who are actually talking about ethical implications of using AI in their legislation. And it's, again, still an ongoing debate, and new regulations are continuously coming into the light. The Central Cyberspace Affairs Commission, which are also the Cyberspace Administration of China, is the body of government that usually creates this legislation. Given the different way the governance of China is organized, the leadership itself, the Communist Party, has a lot of influence about this, and has a lot to say. So there's a bit of a tension. It's not like just one administrative agency doing this, like the US. It's more fragmented, and at the end of the day, because of the way the governance is built, and they have more power over this. There's also an inherent conflict with China, which I think is interesting, because generative AI sometimes create content that the Chinese government does not want to show to their population. So there's a conflict between the values of the Communist Party versus the advancement of technology, and it's an ongoing conflict within China that it will be interesting to see how they will resolve this, again, aiming to win the tech race and at least become some sort of a leader in AI development. They also have a very robust enforcement mechanism. The algorithm needs to be filed for approval, and there are security assessment. If something goes wrong and there's a violation, they can warn or create public humiliation or shaming in public, which is something that is very big in China. And if the violation continues, they can, and there's aggravated circumstances, there's a suspension of the services, or maybe even taking away their license if a license was given. So these are just a couple of countries. All of them are going in different paths, some stronger, some lighter, but everyone is trying to at least have a conversation and see how AI can be safer, but still very beneficial to us as a society.
So let's talk a little bit about continue with the theme of the European Union here. There's a lot of noise and articles and news about the EU AI Act. So where is this? How close is this to implementation at this point? And even if you can tell us a little bit about the process, because these transnational organizations are a little more complicated than any individual country, which just, issues a regulation, gets signed, and we're done. So
yes,
think a little bit about where the EU is here.
Yeah, the EU as an institution and mechanism is different. It's similar to the UN in some ways. They have the regulation or specific acts that they implement, and then they let the member states implement them as well in their local laws. Sometimes the state is obligated to embrace the spirit of the law, but they can do the application whatever they seem fit. And we saw this with a couple of, I think, IP, for example, where different countries had like a specific rule, and they could change it a little bit to implement, as long as it was implemented, and there was some sort of equality between all states. But it takes time, and it takes a lot of agreement in order to actually pass it. So right now, the European Council adopted its negotiated version on December 6, 2022, and then they continued negotiation, and in June 2023, they approved the text, which was not that far long ago. I think generative AI kind of threw them off for a little bit, and they had to go back and change some stuff. I don't think they expected it when they started drafting it a couple of years ago. And the European Parliament proposed a couple of amendments, including additional obligation for foundational models in general and specific application for foundational models used in generative AI systems. Again, making it more robust, but also in that sense, it can scare off big companies. We have more obligations on them. And that's a pushback, a very strong pushback that is going on against this specific AI Act. It isn't expected. Now they are entering the final stage of the legislative process, during which they will negotiate the final form of the act itself. And once the text is finalized, hopefully by the end of 2023, which I'm kind of pessimistic, maybe early beginning of 2024, it will enter into force 1 month after its publication in the journal itself. And then it will there will be an obligation 2 years after. So usually it's published just like the GDPR, and then countries in the EU as well as around the world have 2 years to change whatever they need to change in order to adhere to the new legislation. And they expect it to be in force in mid-2026, as long as everything goes according to plan. So it's a very long process. They take a lot of comments, they change it a lot during the process itself, and especially with something like AI that keeps on changing, they found there were a lot of obstacles. And once it will be written into law, the regulation and the directive, which is another form of regulation that the EU has, the countries will be able to implement it into their own laws, and it will be binding.
Kind of interesting. It's almost like the medical device regulation was passed in 2017 and was 2021 before it actually took effect. And there, COVID, of course, interfered in addition, so there were even other delays.
Yeah, I mean, it's fair because it is a robust one, and there's a lot of obligation and a lot of tasks, and you need to give the companies time to figure it out. The company's lawyers, there's a rumor saying that a GDPR and AI is a conspiracy to give lawyers more jobs. I don't know if that's true, but they have a lot of EU-based companies or companies that are offering services in the EU need to completely revamp their organization and live up to different codes. And the compliance issue of this is something that the lawyers really help. And the EU keeps on creating and giving more job in that sense.
Yeah. So what are the implications here for the EU AI Act? So how is this going to impact companies as they go ahead? Well, and how does this, if I think about the AI Act, it's almost like a twin to the GDPR a little bit. The GDPR is data privacy. This is a data use regulation. If we think about AI as that, so how does that all intersect in this process here?
So thinking about GDPR, I feel like we can see this as a clear, direct continuation of what the EU was trying to do with the protection of privacy according to the GDPR. Here we have a robust framework that everyone else in the world are still kind of struggling with what to do, how to tackle it. It was more challenging with privacy because the notion of privacy in the EU, which is derived from dignity, is very different from the notion of privacy in the US, which is mostly derived from liberty. My house, stay away from my house, and this is where I will have a reasonable expectation of privacy. And given the roots of Europe and World War II, some of our privacy is very much connected to our ability to protect ourselves and our dignity, and not necessarily our ability to protect our house. So that different cultural gap is very much shown in the way that the EU is regulating privacy and the US. Some will say that privacy does not exist in the US. I think that's an overstatement. There is privacy, but it's considered in a very different way, the scope of it. The AI continues that line of robust protection of EU citizens when other countries are refusing to create safety measurements which are enforceable for the sake of continuing to develop the technology and not stifling innovation, which is something that we see a lot within the American approach. Move fast and break things, which is the mantra of a lot of, it came from Facebook, but it's the mantra of tech companies to make sure that we want to, in order to create technology fast, sometimes we need to let go of a couple of safety measurements. We are seeing this right now with OpenAI, with the fiasco that happened with firing Sam Altman for the sake of slowing down and making something more safe, and then him returning with completely changing the board, showing us that safety is sometimes not the first things that companies are thinking about, but rather profit. And that's the stifling innovation approach that we need. We want to move fast. We want to make sure that technology works, and regulation will just stifle that. And we see this in the US. We see this in the approaches that I talked about, the fact that it's very much fragmented and still has like guidelines or proposals, but not like an act or at least a proposal or a bill, like we see with Canada and the EU and China, who have specific regulation. There is a talks about the Brussels effect, meaning that the regulation that comes from the EU will eventually spread to other countries and will settle there. I'm kind of pessimistic regarding the Brussels effect. We can see that the GDPR did some good stuff, and the US changed a couple of stuff in order to adhere to that privacy new standard, but it's not like the US is now the champion of privacy. So the Brussels effect is limited, and it's going to be limited as well in the context of the AI Act, mostly because if we're looking at like the top 10 AI companies, 80% will be the US, 10% will be China, and then 1 will be from the European Union. So the implication itself, despite the fact that the EU is trying to do a great thing, at least creating some sort of responsibility measurements, and the actual effect on the market share is very low at the moment. It's true that these big companies are also offering AI services to EU, and then AI Act will still apply to these situations. But again, it lacks the incentives that we see if AI-based in EU would have had a greater share in the market. So the implications are, in my opinion, are kind of slim, and who knows what will happen until 2026. I mean, we had generative AI exploding. We have no idea where it's going to go again. And that's a problem with regulating AI in a specific form of creating a bill. It takes a lot of time, and by the time we have it, it's useless or obsolete. And that's a big challenge that always exists with law and technology, but I think AI is pushing it to the limit.
Yeah. So in the US, the latest thing that we've seen is this executive order that came out of the Biden administration in the fall, a couple of months ago. Was it September? Sometime.
Yeah.
So that's a different way of doing things. And a lot of it is recommendations, and agencies need to prepare by this date. So I have 2 questions for you. One, let's do law 101 first for us, because a lot of the students here will come from an engineering background. If you can just tell us what an executive order action is first, and then let's get into what it's trying to do in that sense. Because it's not legislation, right? This doesn't have the force of legislation in the same way that a real law passed by Congress would. So what is an executive? Where do executive actions fit in this picture here?
So that's a great question. Executive order is not law. It doesn't go through the legislative process for the Congress or Parliament if you're in the Europe. It is just issued by the US president. And if you read the new EU executive order from Biden, you can see this, my administration, this is what I'm going to do, this is my agenda. So nothing actually went through the legislative process. It's not enforceable not in any way, but it's not enforceable in the way that we look at regular law. It's just the power of it comes from the executive branch of the government, specifically the US president, not binding on everyone, only on employees of the executive branch. So it's And the benefits of it is that we don't have to wait for everyone to agree. So only the executive branch, which are usually in agreement with each other, and that goes faster, but it's not that binding. And we see also with this executive order that it is mostly focused on governmental use and the executive branch itself, because that's the one that they can apply it to. So it's weak form of enforcement that I think is relevant, given the velocity and the speed of this technology. Waiting for bilateral agreement is kind of impossible these days, but it's still, because that it didn't go through the legislative process, it's a weaker form of regulation. And it can vastly change from depending on which president we are currently having. So that's also something that can be scary sometimes.
Now that we have a sense of what it can and it can't do at the enforcement level, what is it actually trying to do?
So it's been almost a month and a couple of days since it was published. There's a lot of scholars working on it and criticizing it, or some of them are actually saying this is a good progress. I'm somewhere in between. So the order itself has like a list of tasks for different agencies and institutions, again, things that are actually can enforce, such as NIST, which we already mentioned, who have their own risk framework. The order is to create reports, propose regulation, give specific guidelines, and it has a specific number of days. So in 90 days, NIST will have to do this or that. So the framework is stable. It's not something that is completely flexible and it will take years to achieve. So the policy outlines a series of actions to be undertaken in the near medium term, reflecting a more nuanced understanding than we saw previously in US legislation of the interplay between AI advancement and the varied sectors they impact. So before we just have like a general AI, we're getting more into details of specific fields. So the EU focuses on 8 topics. The first one is safety and security. The second is privacy of Americans, specifically Americans. Third one is to advance equity and civil rights, which is something that I think AI, wherever it's applied, is relevant. Protecting consumers, patients, and students, which is a very specific aspect of this. Supporting workers, everything that has to do with labor and the fear that AI is going to steal everyone's jobs and will destroy the industry as we know that today. Promote innovation and competition, as well as advance American leadership abroad, which are 2 goals that are usually very much clear when we have American legislation. And there's always a conflict here. We want to have secure we want to uphold safeguards and security, but we also want to lead, and we also want to be the first, and we also want to make sure that we're winning, as I said. And they are sometimes in conflict, but I don't think the executive order does not talk about this, but it's something that I think is worth mentioning. The last topic is to ensure responsibility and effective government use of AI, again, focusing on the people we can actually affect. The private sectors is mentioned there a couple of times, mostly in order to collaborate, get guidance. Academia is also mentioned there as part of gathering information, gathering the report, and having the most information we can before we actually embrace regulation that is being offered by those administrative agencies that should have the expertise to do it.
So when we talked about this before, when we compare this to the EU AI Act, the EU AI Act feels a little more like a medical regulation, has risk factors, classification by risk, high risk, medium risk, low risk. The executive order is more like by sectors and fields, defense, health. So what are the other sort of comparisons between the 2 other than just that? And where are we? How compatible are they? Are we in 2 different planets, or is this similar in many ways?
I think the gap narrowed. We're still the planets came closer together, but we're still on not completely, but different planets. I think the most important thing that is missing from American regulation is actual enforcement, which we see that the GDPR and the AI Act did viciously. The 6% of global turnover is a lot of money for these companies, and it's very substantial. And the US, even though they have a couple of at least offering regulation or calling for proposing a framework, don't say anything about how to actually enforce it. I mean, everyone wants the why is it's very clear that we all want them to be ethical and safe and responsible and transparent and accountable, but no one's telling us how to do it. The EU is trying to tell us how. If you have a high risk, you have to give me registration. and give me evidence and reporting. But the US is not giving us the how yet, even though they are stating we need to advance equal and justice. We don't know how to do it yet. And the executive order should narrow that how, big question mark, by asking the people with expertise to tell us. But again, this is just like a call for information and not an actual legislation that can be heavily enforced. I'm not sure if, I think there's a good reason to classify by sector and not necessarily by risk level, because it's AI is very nuanced. And like I said in the beginning, AI means one thing maybe to policy people, but a lot of different things to AI people working from the STEM perspective. So going over it from a context of how to use it, I mean, using it in a criminal justice system is very different from using it for buying stuff online or for health purposes. In that sense, it makes sense to divide it into specific sectors and rather than create a classification of risk. Again, I might be wrong, and time will tell what's the better approach. Obviously, we will be able to see because they are taking very different approaches right now. But both of them are the values, the core values underscoring everything are shared. It's just the how to get this is very different because the EU is trying to create a very robust framework and very strict on everyone to make sure that they're not putting this technology out there, causing a lot of damages before we are actually ready for it. And again, the US is taking a very different approach, saying we need to put it out there because that's how AI learns. It needs more information, and creating more regulation will probably just stifle it, and we don't want to do that. So again, I think it narrowed the gap, but the agenda, unlike the underscored values, are different, and they are pushing it to different directions.
Mm-hmm. So let's just focus a little bit. So this is a certificate program on medical software, medical AI. So let's look at a little bit what the executive order has for the healthcare sector, for the whole medical sector. So what is the specifics that affects this part of the economy, I guess, or people working in this area? What are we looking at?
That's a great question. So I've been talking about AI regulation, but there's a specific sector, and the executive order talks a little bit about this in the context of healthcare. The EU does also that regarding most of the things related to healthcare, such as biometrics, as very high risk, and then you'll have a lot of obligation to carry out in order to do that research. But if we are shifting our focus to the US for a second, so if we're talking about patients in healthcare, the executive order calls to advance the responsible use of AI in healthcare. Again, this is kind of a slogan and less of a how, and the development of affordable and life-saving drugs. Again, something that we all obviously want. And they call on the Department of Health and Human Services to establish a safety program to receive reports of and act to remedy harm or unsafe healthcare practices involving AI. So we have some sort of a body who's giving responsibility. Nothing formal, nothing with teeth, but still some entity that at least have the responsibility to do something. The Department of Health and Human Services is tasked with instituting a safety initiative aimed at gathering data and mitigating harms or unsafe practices in the healthcare involving AI. Again, we have a body, we're now creating an initiative, and they have the responsibility to gather information and, to the best of their ability, mitigate or prevent even harm that is associated with AI in the healthcare perspective. More consumer-oriented, but still relevant to patients, if we're seeing patients as a consumer of healthcare, which I think we are. Independent agencies, including the FTC and Consumer Financial Protection Bureau, are encouraged to enforce existing consumer protection laws, which can be relevant to medical devices and medical services more broadly, and principles concerning AI. There is also a call in the executive order to introduce new safeguards to shield consumers from AI-related risks, such as fraud, bias, discrimination, privacy, and safety hazards, which are abundant in the context of using algorithms and AI to make medical decisions. Focusing on critical sectors such as healthcare, they also mentioned financial services, education, housing, law and transportation. But healthcare is one of them that they're saying that the FTC and the Consumer Bureau should be responsible. But again, I'm reading part of what the executive order actually says, and it's very, I mean, their heart is in a good place, and I'm not really sure what it actually means. It's not saying anything but saying everything, if that makes sense. And the particularity of the next step, which I hope this is just like the preparation stage, will have to take all the information and the initiative that they are calling for and actually say, this is okay, this is not, creating not necessarily rules which are strict, but standards. So the difference between a rule and a standard, which we talked a lot about in law school, a rule will be don't drive over 80 miles per hour, a standard will be drive safely. So if we have a rule, especially with AI technology, that we can't really keep up, not giving the flexibility of having a general standard is kind of hard. So I do expect them to go to the standard avenue, but they have to create something. And hopefully the information that they gather now, even though I think they should have enough information by now, but this is another push to transform that information to something usable.
Yeah, I mean, reading the act and listen to you speak, I can summarize it. We want to promote good things and prevent bad things, but after that, it's sort of very...
Yeah, bad things are going to happen. We're going to need to face them. There's a couple of guidelines and you go. That's the essence of this, which is, again, important, but it's not saying what I expected it to say. Even though a lot of people consider this to be a very a big step towards the right direction. It's not like actually acknowledging the problems, but giving like academia discussion and public discussion about generative AI and AI more generally, I think that is also already a given. So
one of the interesting things about this whole, and I don't even like the term AI, but let's use it here, the whole explosion of AI. For us who've been working in the medical world and medical software, is that up to now, with the possible exception of GDPR, we've been left alone with our own regulations in our own corner. You know, the FDA rules, the medical device regulation in Europe, it was a self-contained sector in some ways. Now with AI raising to this level of, I don't know, importance, awareness, public interest, there are other things that are affecting us now. Sort of general regulations are coming down. So if you are doing work in the medical sector, medical device sector, drug development, what do you need to monitor here? How do you think these things are going to impact us?
That's a great question. So I think right now it will not have a great impact just because it's very much in the phase of what do we do? But it should, the monitoring of the regulation and the policies that are being published is something that is very important, especially if the FDA decides to take control or take some sort of a lead and create specific regulation, as the original plan was to create the FDA in order to make sure that medical devices that are being put in the market are safe, at least to some extent. Now that the FDA, in my opinion, lacks some of the expertise that they need to actually approve this, we are in a situation on top that is kind of problematic. On top of that, even if they approve, who's to say that in like a couple of months, there's a better design, an alternative design that is safer. So maybe the structure of an FDA for algorithms that approves is not the best way to go. But right now, working with existing infrastructure, I think will be the best thing, because we lack the time, lack the resources, and sometimes lack the expertise to create solid regulation. And we see this with the bills and the attempts that are being carried on with not a lot of success, because everyone wants to regulate it and they're not sure why. And this shows, I'm going to go back to the monitor question in a second, but I want to make a side point. Regulation usually has like a knee-jerk reaction to new technologies. Something new comes and everyone panics, and then they have very strict regulation, not sure what they're going to do. It's too dangerous. No one can use it. We saw this with hot air balloons when they started. We saw this with airplanes. The first intuition is to ban it, or at least exclude it very generally, until the technologies, the benefits of the technologies are made aware. Here, everything kind of got confused, because we're just allowing everything, even though we have no idea what's the safety implications, because AI has the hype it has. And that's dangerous. I would prefer of saying, let's do a moratorium, stop for a second, and then maybe have some more information and continue, other than this is so important, we can't stop it. If we stop, we're gonna die or lose or some other catastrophic event. So here we see a kind of different approach to AI. We did see this with other instances, for example, cyberbullying, which I did a little bit before coming here. Because there was a lot of public pressure, they created legislation, which was horrible, because it kept on violating the First Amendment. And we're seeing kind of the same with AI. There's a push to create regulation, so we're doing it fast. And I'm not sure if that regulation will not be horrible, because the definition is too broad or too narrow. It's not going to be applicable maybe in a couple of years. The risk classification or the standards that are we deciding to take right now are not necessarily the best, and that will be applicable in the next couple of years. So public pressure sometimes and fast-track regulation sometimes creates bad regulation. And that's why I think regulation is not necessarily the best approach here, given the velocity and the scalability of this, but I will talk maybe a little bit more about that in the end. When talking about monitoring what's going on, the regulation right now is super slow, fragmented, and sporadic. They're trying to pick up the pace in some places, such as the EU, because they've been talking about it for years. They want to bring something to the light. The US is taking the time, I think, on purpose to allow things to progress, to get more information. And as I said, treating AI as one thing is problematic. And AI in the healthcare is completely different than AI in the criminal justice system. We have civil rights that are being put on the line, but they are very different contexts, and the balancing act that we need to do is different for each of them as a society and as people who value one thing over another. If I focus on the EU Act, as I mentioned, medical devices that are using AI can be classified as high risk. So working in the EU or marketing medical devices to EU citizens can be costly because there's a lot of obligations, and a lot of companies don't like that. They will do it, obviously, because they cannot not offer products to EU citizens. That's discrimination, but it will probably be some sort of it will create a situation where the incentives to actually manufacture new stuff will decline. And also they will have to show with high risk classification that it's not the usage does not pose a significant threat to health, safety, and fundamental rights, which can be hard to prove because we're working in the health sector. Something might be dangerous, and it's just a feature of the medical device and not a bug. I already talked about the high risk. Specifically with the US, there's more specific discussion about healthcare, as I mentioned. So keeping an eye for the initiative or the guidelines that will take probably a couple of months to publish, but seeing what they're leaning towards and then trying to align the practice with them, just in case this will be law in a year or two.
Yeah, no, this is all a brave new world, not least because nobody knows what AI is. When I teach, I tell students my operative definition of AI is that something that can be done by a computer, because that's about the level of specificity we have right now. Mm-hmm. It's an interesting story. We have a technology that we can't define, that we're trying to regulate. We have disagreements as to what it means. I don't want you to get into that, but no, so many definitions that it's kind of interesting.
Yes, but I just want to mention the US Supreme Court, when he talked about pornography, for example, said, I know it when I'll see it. Maybe the same standard should apply to AI. Hopefully, person seeing it, he's someone with expertise. But trying to create specific definition can be very hard, and maybe AI is a social construct, and we need to think about that as well.
Yeah.
So yes,
it's an interesting story. So I've learned over the years of doing this kind of Q&As to end the session by saying, is there anything you would like to add? People have more interesting things to say than I've asked them to, so I'm opening it up to you, Anat. So anything we missed, anything that you think is important for students to know as they grasp issues?
Yeah, thank you for giving me the stage for that. So I would just want to say a couple of words of my specific field of research, which is insurance. Specific liability insurance, and how it can help regulate this new technology, quasi-regulate. So because I said that maybe we lack expertise, maybe we lack the time, maybe the regulation by the time we're there will not be relevant anymore. There's a void that insurance companies can step into. Insurance company inherently has the ability to nudge our behaviors as policyholder. Think about you driving a car, having an insurance in place. If you get into an accident, your premiums will go up, you have copay, you have caps. They can nudge us and give us loss prevention tools, because they have the ability to accumulate a lot of information and tell us what to do to be safer. Allegedly, they were the one pushing for legislation of safety belt and airbags in our cars to make sure that we don't get hurt, because in that way they will make more money. It's very cynical. They are an entity driven by profits. But because of the privacy, the alignment of interests, that can be of good service to us who want to try new things with AI and new technology, but want to hedge our risk in a beneficial way, which insurance offer policies covering that specific thing. If we're talking about products that are creating, we have products liability, and I know insurance exists for that. If we have users who want to try with new devices, they can do that maybe if they have some sort of policy in place. Obviously, manufacturers can get that. It's not a silver bullet, obviously. There are exclusion and caps and stuff that make sure that we have skin in the game, so the moral hazard risk concern will not dominate, and we just know someone else will pick up the check, so we will act recklessly. So I just want to put this out there and let students know that insurance is a thing that we can use, and sometimes is starting to being used more as a regulatory mechanism, soft law, as a lot of people like to call it, for the insurance companies to nudge their policyholders to a safer behavior. And I think that can also help in the healthcare field.
Yeah, and I mean, we see that in medical products in general. Like when the FDA clears something for use, basically says, it looks like you followed all the rules and we think this is safe, but you're still liable if something goes wrong. And that has a secondary form of enforcement for a lot of these risks. Like the FDA giving you clearance doesn't mean the FDA says, oh, this is good, we put a stamp for approval. It means you can start selling it. We think you're doing all the right things, but you're still liable. So liability is like our backup plan in many ways here. And insurance indirectly controls that expense. Yes?
Yeah, liability insurance is very much intertwined. Not a lot of people talk about insurance just because it has a very bad reputation. We don't like it in the context of health insurance, and I don't blame anyone for that because it's kind of horrible in some points. But in liability insurance context, making sure that better devices are being put in our commercial stream, I think it has the ability to do so. To do that, and it has been doing so since the days of the steam boilers and hot air balloons and stuff like that. They have incentives. We just need to give them the way to do it. So maybe some governmental backup, or to make sure that they have the reserve something if like a single event triggers a lot of policies at once, which people say AI can as a catastrophic situation. So it's an institution to be taken into consideration, but again, not a standalone solution.
Okay, I think we'll stop here. Thank you for taking the time.
Thank you so much for having me.